welcome everyone to our program. My name is Victor Gold, and I'm joined this morning by two of my colleagues, Bob Bryan and Bryan Hull. We all teach contracts, and we're here to discuss COVID-19 and the issues the pandemic has raised under contract law. We have quite a few people registered for this program, so all of you have been muted to allow us to give our presentation, but feel free to post questions in the Zoom chat function, and we'll attempt to answer the questions at the end of our presentation as time permits. So there are three of us, so we're going to divide the discussion into three parts. Bob Bryan is going to discuss the effect of force majeure clauses, and Bryan Hull will discuss the application of the contract doctrines of frustration of purpose and impracticability. And I will finish the presentation by addressing several other contract law issues or provisions that might be in a contract that are conceivably relevant to COVID-19 problems. And then I'll make a couple of practical suggestions as to how to deal with those problems. So in the discussion, we'll occasionally make reference to a couple of hypothetical cases. So maybe, Bob, if you want to switch to that slide, here are the facts. The first one, Samsung rents a booth at an electronics trade show, paying up front in full, but due to the concerns about COVID-19, the owner of the event cancels the show and now says it's going to apply Samsung's payment to a booth in next year's show. And there's nothing in the contract that specifically addresses what happens in the event of a cancellation of this sort. Okay, so that's hypothetical number one. And here's the next one. A father books a wedding venue, planning to invite 300 guests to the wedding of his child. Government regulations at the time the wedding is scheduled will permit the service to take place, but social distancing requirements will limit the attendance to just 30 people at this venue. So those are a couple of examples of the sort of problem that might arise, contract problem that might arise in connection with COVID-19. So without further ado, I'm going to ask Professor Bryan to talk about force majeure.
Hey, everybody. Like Victor and Bryan, thank you for taking time out of your day to come and listen to us, and we'll try and make it worth your while. So let me do a, kind of a general thing on force majeure clauses. This is stuff I suspect you all know, but at least it'll give us a chance to start from the same place. So what they do is they allocate risks. They say that here's a risk that we can foresee, an act of God, war, pandemic, whatever, and then when that happens, this is what that effect will have on our contract. And that's really what force majeure means. I mean, roughly translated, it means strong, a stronger force. It has greater force than the general law because the parties have specifically allocated the risks. Now, traditional force majeure clause really act as conditions, right? I'm going to provide you with this good or this service on the condition that there's no war. Right. So, and often they're written that way as specific conditions. Now, there's been creeping in a couple to some transactions we've seen, kind of what they call reverse force majeure clauses, which I'll talk about in a second, which says we foresee this risk and the parties were going to go forward despite even if that risk happens. And that, of course, isn't a condition, but as I said, I'll talk about that a little bit more in a minute. So if it gets to litigation, they act as a defense, right? When party says, hey, I know that I'm asserting that a pandemic has occurred and is covered by my force majeure clause, so I'm not going to perform. And the other party then sues for lack of performance. And if the non-performing party is right, the force majeure clause acts as a defense. Now, usually, right, they're boilerplate, and with all boilerplate, nobody cares. It doesn't really matter until it's the only thing that matters, right? Because that's the whole contract hinges on that. And as with most litigation involving contracts, courts try to discern the intention of the parties. But when it's boilerplate, you just take it from the last deal and you tweak it a little bit. There's often not much attention paid or not an intention of the parties as to what it covers. So courts then become textualist. They sort of say, well, look, if nobody paid much attention to that, let's look at what it really says and the plain meaning of the terms, and we'll figure out whether it's covered or not. So what that means is that there has to be a good deal of care given in drafting it. And what we've seen over time is when there have been big historical events like World War II and 9/11 and now COVID, people start paying more attention to how they draft force majeure clauses. So some of what I'm going to talk about in force majeure is going to be on the drafting side. Some of it's going to be on how courts look at it. But that's kind of the idea behind force majeure clauses. They are the parties anticipate some event. They decide what's going to happen if that event occurred. So force majeure clauses have 5 components. The first is, of course, a list of the triggering events. And these are the things that you've seen, the act of God, pandemics as declared by the World Health Organization or something. Now, as when my last slide, when I talked about courts become textualists, you'd think you want to be as specific as possible. And you certainly want to be as specific as you can, but some early adopters of a pandemic clause got into trouble because they said if it's a stage 3 pandemic as declared by the World Health Organization, which is how at the time the World Health Organization declared pandemics. There was a level 1, a level 2, and a level 3. They've gotten rid of that now. So what do you do with those clauses? So, you need to be as specific as you can, but you need it to be broad enough to cover potential changes. And again, I got some suggested language that comes up. The second is they always have a catch-all phrase, something like, or any other occurrence beyond the party's control. Now, that's an important feature because if it's not beyond the party's control, you've got illusory promise issues, right? If I can control whether the event occurs, then arguably we don't have an enforceable contract. And usually that's not an issue. Where it's become an issue occasionally is in strikes. So, in some sense, if I can't perform because my workers have walked out, that's kind of within my control. I mean, I could accede to their demands, but most courts have said, we're not going to presume that you have caused some kind of labor strife just to, avoid a contract. And so generally strikes are okay, but you will see some drafting that says strikes other than by one of the parties to the contract. Now, here's kind of an interesting thing because it's not uniform across the country how these catch-all phrases are interpreted. And obviously, if you signed a contract in November, you probably didn't have a pandemic clause in it. So there's this doctrine that, I don't know, I can't pronounce this stuff, but jusdem generis, which essentially means that if you have listed a bunch of things, then there's a presumption that what is not listed is not included. And the New York courts, and it's prominent because it's New York and such a commercial center, the New York courts have been absolutely following this doctrine. And so these catch-all clauses mean nothing in New York. So that if you don't have a specific thing covered, then you're not going to get force majeure relief. Now, California courts are a little more forgiving about that. They will look and see if it's the kind of thing that really wasn't, I won't say it wasn't foreseeable, but it wasn't immediately foreseeable. And so California courts may give you some more leeway if you're trying to get stop performance because of the catch-all phrase in a force majeure contract. And that also means that choice of law clauses can become even more important. If you have a general choice of law clause that says New York law will apply, then, right out, unless there's a change in the law because of COVID-19, you're not going to be able to rely on the catch-all clause. Whereas if you say it's governed by California law, you might have a better chance. And I would say really the courts are split throughout the country. So you need to, that has to be at least one factor in your choice of law clause. The next part of a force majeure clause is the triggering standard, what causes whatever relief we're going to say to happen. Now, the minimum in a force majeure clause is something that says rendering performance illegal or impossible. That's pretty strict. Because impossible means impossible, right? Think about our wedding example. It's not impossible to hold the wedding. It's impossible to hold it as the father wanted, but it's not impossible. So if you want to broaden it up a little bit, if you're on that side of the transaction, the two other phrases that often get added, and of course, in any individual contract, there's more or less, but generally, is that you say rendering performance inadvisable, impractical, illegal, or impossible. Now, another thing that does have an effect on choice of law, on force majeure clauses, is a time is the essence clause. If you think back to our Samsung example, if you interpret the contract as saying, well, Samsung paid for a booth and the promoter promised to give Samsung space for the booth, it doesn't say that has to be in 2020. That could be in 2021, or at least that would be an argument. And if you have a time of the essence clause, or if you narrow it down and say that it is a fundamental part of this contract that the booth be provided in 2020, then the more the better argument you have to say that performance is impossible. So things you might not have thought about in drafting these things, but choice of law and time of the essence clauses can help the party who's trying to assert the force majeure event. Then there's the effect of when the trigger is met. So there has been a pandemic declared by the WHO, and what does that mean? Well, the two most common phrases are the parties shall be excused from performance, or the contract, the duties are discharged, something like that. Or the parties shall be excused from further performance. And that means that if you've paid a deposit, then the provider of the goods or the services gets to keep the deposit. So the further language is something you need to pay attention to as well. Now, I mentioned that there have been kind of reverse force majeure clauses. Victoria's Secret was sold recently, and so the owners of Victoria's Secrets were the sellers. The deal closed in mid-January. They said, we know there's a possibility of a pandemic, and the parties agree that we will go forward even in light of COVID-19 ramifications. And obviously, I'm paraphrasing, but that was the gist of it. So you can actually now allocate risks and not saying the contract is over if they happen, but that the contract will go forward because the parties have contemplated that risk. Then the fifth part of a force majeure clause is that some kind of notification requirement. When are you asserting force majeure, and how do you do it? So let me look at one kind of just general. This came from Williston on contracts. Can't get much more kind of black letter than that. This was done before pandemics and stuff, but this is a very typical one right here. The triggering things: acts of God, war, government regulation, disaster, strikes. The Williston author said, except those involving a party to this contract idea. And then the catch-all clause, right? Or any other emergencies beyond the party's control. And now they are recommending that you use inadvisable. As I said, if you want to use, you could make it even broader and saying impracticable too. But you see, inadvisable gives the father of the bride some wiggle room. Right, that yes, it can't go on. It can go on. It's not impossible, but it's inadvisable given the circumstances. Or if somebody could put on a convention, but people don't want to fly there, it may be inadvisable to put on the convention. That sort of idea. And then either party can cancel the agreement upon the occurrence of one or more of these events, and a very simple notice requirement upon written notice to the other. Often you'll get upon written notice within 30 days after the triggering event. All right, so Bryan found the ICC has just come up with kind of a white paper where it talks about force majeure events. And if anybody wants these slides, go ahead and email me. I'm happy to send them to you. But you could Google ICC force majeure and you will get this. And they have a list of things you can check off, sort of what applies to your deal, what doesn't apply to your deal. And it's more than just the triggering events, although the triggering events is what I put up here. So kind of two of the more newer provisions are the ones in yellow. So currency and trade restrictions, which people hadn't given much thought to, but became a little more prevalent after 9/11, embargo, sanction, and then the one that faces us today: plague, epidemic, natural disaster, or extreme natural event. And you see, here's one that, there's wiggle room, right? I mean, I don't think COVID-19 doesn't qualify as an epidemic, but what's a plague? What's an extreme natural event? But at least it gives you the basis for starting negotiations if you have such a clause. Now, a couple other things that I've seen that you might want to think about are using kind of more of the language of today. Should you put in your contract shelter-in-place orders? Is that a triggering event? Quarantine per government regulation. And one that is kind of very recent, and again is not real specific, but maybe gives you some room to argue, is if there's been substantial interruption of air travel for a convention site or a trade show or something like that. So that's kind of the most up to date I can give you about force majeure clauses. And now I will turn it over to Bryan to talk about impossibility and practicability and frustration.
All right. Well, thank you very much, Bob. Would you mind moving the slide forward to thank you? Thank you very much. Good morning, everybody. Hope everybody's doing well out there. I'm going to talk about the use of the impracticability or impossibility defense, and also the doctrine of frustration of purpose, which may be relevant if we're talking about a situation where the contract does not specifically address the kinds of things that Bob was just talking about, and where due to COVID-19, and maybe governmental regulations that are attendant to COVID-19, whether it has now made it impossible to perform or impractical to perform, or where the purpose of the contract has now been frustrated, maybe because people don't want to show up for an event due to fear of infection. So when I talk about impossibility and impracticability, when I teach contracts, I refer to these as stuff happens defenses. So people enter into contracts and something happens, and now it's become impossible to perform, or it would be ruinous financially to perform, or the whole reason for the contract has gone away, and now somebody doesn't want to perform. So can they get out of the contract? Can they be discharged from their obligations? One thing we should understand is that these defenses are rarely successful. Courts are extremely reluctant to grant relief on this basis. But these are unusual times, and these may be the situations where these kinds of defenses actually will work. So first, addressing the impossibility or impracticability defense, and it's maybe helpful to understand sort of the origin of the modern application of this defense, the famous Old English case of Taylor against Caldwell, where Caldwell had agreed to supply his music hall for some musical performances. The music hall burned down through no fault of Caldwell. The person who was going to perform sued for damages based on expenses incurred in preparing to perform. The court granted relief, saying that Caldwell was excused because the music hall was sort of, the existence of the music hall was a basic assumption on which the contract was made. And when it didn't exist anymore, now it wasn't possible for Caldwell to perform. So excuse was granted. Since that time, the law has been broadened somewhat to allow this defense to be used in cases where performance is impracticable, not just impossible. So when we talk about impracticability, though, we're talking about situations where maybe expenses have gone up dramatically due to some disaster, and now it would be ruinous for a party to actually perform. And I want people to understand that we're not just talking about a little bit of a loss here before courts will grant relief on this basis. We're talking about very significant losses that maybe would be ruinous. Courts have said that people have to perform even when literally they're going to lose millions of dollars. So this defense, as I say, is rarely successful. But when we talk about COVID-19, we're talking about governmental orders being handed down forbidding people from doing business. So when you have that situation, courts will often say that the absence of a governmental order is basically a basic assumption on which contracts are made, that the government won't say that what is being promised is illegal. So when we talk about COVID-19 and government saying you can't run a restaurant, or you can't run a gym, or you can't host a big wedding, or you can't host a trade show, I mean, those are classic situations where somebody could raise this defense of impossibility and be excused from performance. When we talk about the other elements that are up here on the board, no fault of the party claiming excuse, that's not likely to arise when we're talking about this situation of COVID-19. Where you could perhaps have an issue is with regard to whether risk should be allocated to the party that's claiming excuse. And obviously, if parties are drafting good force majeure clauses, maybe they can make that clear. But if they're not, then you could get into a question about whether or not somehow the contract should be interpreted as allocating risk to the party that's claiming excuse. When courts consider this, they look at the language of the contract. They also look at the foreseeability of the event, whether the event is sufficiently foreseeable that we would expect the parties to have accounted for it in the contract. Again, when we talk about COVID-19, though, we're talking about something that's pretty unprecedented. I mean, contrary to popular belief, I wasn't around during the Spanish flu epidemic, but so really, I haven't seen anything like this in my long lifetime. And so I think one could say that you wouldn't necessarily expect the parties in the contract to really account for something like this, and therefore we should be reluctant to allocate risk to a party who is claiming they should be excused due to some governmental order issued pursuant to COVID-19. California pretty much follows this approach. There's a civil code provision, section 1511, that specifically deals with this. The California Commercial Code, which is the California enactment of the UCC, has the provisions that are up on the slide. And then there's this kind of interesting case, the Autry case that Bob also had in one of his slides, that involved the famous singing cowboy, Gene Autry, who was excused from performing in making motion pictures for Republic Productions because he went into the Army. And in that particular case, actually, the parties sort of conceded that he wasn't drafted, but it looked like he was going to be, and then he signed up. They pretty much agreed that that was a sufficient excuse. At least it suspended his obligation. Ultimately, the court held that it not only suspended his obligation to perform, but actually extinguished it. So anyway, that's kind of a famous case, kind of an interesting case for those who maybe like baseball. Remember Gene Autry is the owner of the Angels, and maybe remember him as a singing cowboy. I want to give a shout out to one of my research assistants, Amy Tract, for coming up with this old case out of Delaware, where the court said in dicta that an epidemic of sickness would constitute an act of God. So it was dicta because this wasn't really relevant in the case, but nevertheless, we see that courts might very well say that this sort of thing definitely is a situation that's not anticipated and could give rise to the doctrine of impracticability or impossibility. Could you please advance the slide? Thank you very much. So here we now see a picture of me standing in front of a statue of King Edward VII. And you may wonder, why the hell are you putting this slide up? So the reason why is because the doctrine of frustration of purpose actually arose out of the coronation of King Edward VII. And he succeeded his mom, Queen Victoria. She was on the throne a long time. When she passed away, people were very excited about the prospect of a coronation procession. They rented out rooms to watch it. Unfortunately, Edward came down with appendicitis, and the coronation procession was indefinitely postponed. So the people who had agreed to pay for these rooms, they didn't want to pay. They didn't want to rent out a room and sit there and watch nothing. So they basically said, I shouldn't have to pay because the purpose of this contract has been frustrated. And this was a relatively revolutionary ruling at the time. The court saying, well, yeah, you could perform. There's certainly no reason why the people who rented the rooms couldn't pay, and it might not even hurt them financially to do so. But the court said that because both parties were aware of the principal purpose, which was to watch this coronation procession, it didn't make sense to go forward with the contract once the procession was postponed. So therefore, the people renting the rooms were excused. And this doctrine has made its way into the US, but I want to say that, again, it's very infrequently applied, very infrequently successful, less so, I would say, than the doctrine of impracticability. And again, we should keep in mind, normally a deal is a deal. So courts are reluctant to grant relief on this basis. But the elements for the defense of frustration are very similar to the elements of impracticability. So the principal purpose of the contract, which both parties must understand, is substantially frustrated by an event, the non-occurrence of which is a basic assumption on which the contract was made. So we can see that if the purpose of a contract is to gather people together for some event, and now because of the governmental order arising out of COVID-19, that can't happen, we can see how the purpose of a contract would certainly be arguably substantially frustrated, and that might then give rise to excuse. Again, fault is unlikely to factor in when we're talking about COVID-19. We do maybe get into questions again about whether the contract allocates risk to the party claiming excuse. Again, it's unlikely we would say that this situation was particularly foreseeable at the time of contracting, at least assuming the contract was entered into at some point before the pandemic. There is California authority for this, Civil Code 1932. The Lloyd against Murphy case is actually viewed as one of the most significant cases in the United States dealing with the doctrine of frustration, an opinion issued by the great Judge Roger Traynor. But after going through a big, long analysis of the doctrine, he said, I'm not going to grant excuse here because the purpose was not substantially frustrated. 20th Century Lights, I want to give a shout out to my RA, Jamie Olashansky, for coming up with this particular case. As I said, it's very difficult to come up with cases or find cases where relief is granted on the basis of frustration, but Jamie came up with this one and a couple of other ones here in California where excuse was granted. And the 20th Century Lights case arose out of World War II and an order of the government basically forbidding the use of illuminated signs. So since the contract called for an illuminated sign, the court says that the purpose of the contract was substantially frustrated and granted relief. So there are some cases where this excuse works, but not too many. Annie came up with a couple of Spanish flu cases that, even though the court doesn't necessarily refer to them as frustration cases, they really, in my opinion, are. One where schools were closed due to the Spanish flu, but the court says the district still had to pay the teachers. Another one where the schools are closed due to Spanish flu, and the court says that you don't have to pay the bus driver. And then there actually is another case that I didn't put up here where the court said that another district had to pay the bus driver. So, this is going to be one of these areas where courts are not necessarily going to be in agreement on how they ought to come out. And one thing I read once from a legal commentator was the doctrine of frustration is frustrating because of the uncertainty in its application. And impossibility doctrine is impossible because it's so hard to apply. So I think one thing that parties should think about when deciding whether or not they should just sort of call the deal off is the fact that if they go to court and try to fight about this, it's sort of unclear how ultimately things are going to come out. So now, Bob, if you would please advance to the next slide, and I'll apply the law to these facts. So the first one, Samsung rents the booth and the trade show is called off. So I could really spend a lot of time doing the ins and outs of these things because there are some things that you'd want to know, but I'm going to just sort of cut to the chase because of time. And, I'd be happy to talk more about this later if we have time with people who wish to do so. But in any event, this first one strikes me from Samsung's perspective as being a case of frustration. The Samsung's contracting, the only reason they're renting this booth is because of this trade show. When it's called off, the purpose of this contract seems substantially frustrated. Now, normally, when frustration arises, at least if the duty is a material duty that is being excused, basically both parties are allowed to call the deal off. And normally, restitution is available. Now, in this particular case, the owner is trying to push things off to next year. What I would say is that that's probably material. And it would be one thing if they were pushing it off a week or pushing it off a couple weeks, because then maybe time is not of the essence, and maybe we would say that Samsung has to put up with that. But putting it off for a year, I would say that to say that Samsung has to commit for another year would be a bit much. Now, one thing I will say, though, is that from a business perspective, it might make sense for Samsung to play along here, because if this trade show is a useful one for them, and if they like to go every year, it might make sense for them to get along with the owner. And frankly, they may not. It's in Samsung's benefit, frankly, that the show isn't going on, because do they want to have a booth at the trade show right now with COVID-19? I mean, how many people are actually going to show up? And what about the poor people that have to work at the booth? Do they want to work in the booth and meet people that come through? I would say probably not. So really, from the perspective of both parties here, it might make sense to try to work out some kind of an arrangement. The second situation, the father books the wedding venue, planning to invite 300 guests. So to the extent that the venue has made a promise of accommodating 300 people through setting up tables and chairs and providing food and whatnot, I think one could certainly argue that they are excused from that performance due to the fact that there's a governmental regulation in place that's forbidding this. So it would be within their rights to say, well, we can't perform. And then maybe again, we get into the question, well, how long is this going to go on? Dad may not want to have an indefinite suspension here of time. Dad might prefer at this point then to just call the deal off himself and get his money back. And I would say he probably would be entitled to that under these circumstances. But if what happened is that the venue didn't necessarily make any promises with regard to the number of people, and it's just a venue and Dad's renting it out, and let's say Dad's going to bring the furniture or rent the furniture, going to provide a separate caterer, I mean, one could argue then that the purpose of this agreement is not substantially frustrated because the dad can still have a wedding, and he can have the wedding for his child. Maybe they're not going to have as many people showing up, but the wedding can still go on. Maybe he would have liked to have 300 people there, but if you define the purpose as having a wedding and a reception, that can still go on. So what I would say is that in this situation, again, it probably makes sense for Dad to try to work something out with the venue. I actually have a friend who raised this very question with me. He's putting on a wedding for his son, and this is kind of what he's going to do. And, you know, it makes sense to work it out. You like the venue, you want them to stay in business, you want maybe just push it off over time and use the venue when it's more appropriate to do so. So in closing, I just want to say that when we talk about the law in this area, it is quite unclear. These defenses are rarely successful. There is authority for the proposition that courts should not view this as all or nothing, that if the parties aren't willing to actually make accommodations, maybe the court will step in. Courts tend to be reluctant to do that, but my counsel to any parties who would be involved in situations like this would be that it's probably from their best interest to try to work something out and not leave it up to the courts. So maybe I'm part of the sort of relational contract theory group of people that views contracts as relationships. When stuff happens, people should try to work stuff out. And that's the advice I would give in these situations. And that concludes my presentation. On to Victor.
Okay, thank you, Bryan. Bob, you want to put up my first slide? So whether or not there's a force majeure clause, whether or not the facts allow for the application of the doctrine of impracticability or frustration of purpose, there might be other provisions in the contract that are relevant to a COVID-19 related problem. And there are other parts of contract law that might be relevant. So that's what I'm going to talk about. So the first thing to look for in a contract, after you look for the force majeure clause, is whether there are other termination provisions. They might be entirely separate. And what you need to do is look for them, read them, work with the language to see if they are applicable. Now, whether you're considering arguing that a termination provision applies or it doesn't apply, whether you're considering taking the position that the force majeure clause applies or doesn't apply, whatever legal position you might want to advance on behalf of your client, you need to be careful. And so here's an extra little bit of contract law to worry about. If you invoke a stance and refuse to perform, then based on that position, someday a court might decide that you just engaged in what's called anticipatory repudiation, which is typically regarded as a material breach. I'm going to talk about more. I will talk in a couple of minutes about what that means, but you need to be careful about invoking the force majeure clause or invoking impracticability, frustration of purpose as bases for discharging your duties. At the same time, you have to be careful about not asserting your rights and running the risk of waiving them. So whatever you do by way of invoking the contract doctrines that we're talking about today, you have to be careful about how you do it, what language you use. And in connection with that, if there is a termination provision that you think might be applicable, those clauses, those provisions usually require the giving of notice. So again, if it's your client who is seeking to terminate, make sure you comply with the notice requirements. If you don't, you may have waived your rights. There could be other provisions in the contract that are relevant. There might be a time extension provision, a provision allowing for price adjustments that could be applicable depending on a change of circumstances like the sort we're seeing in the hypotheticals that are caused by the pandemic. So you need to be mindful of those types of provisions. So these are things that are short of asserting that the contract is unenforceable, but allow you to take sort of a middle ground position where maybe now you can contend that, well, we need more time to perform, or we need a discounted price, that sort of thing. There might also be a provision in the contract involving a promise of indemnity, or also a promise to acquire insurance. Now, an indemnity provision, that's a part of a contract that suggests that one party is going to stand for or be responsible for the losses incurred by the other party to the contract, depending on the causes, the circumstances, etc. So you have to read those provisions very carefully to decide if they might be applicable to the pandemic situation. And again, this is totally independent of whether there's a force majeure clause and whether the force majeure clause is applicable, assuming there is one. If there's a requirement that one of the parties buys insurance then to cover losses, you have to read that provision carefully to see if maybe that is applicable in these circumstances. And if the insurance was purchased, now you got to look at the terms of the policy carefully to see if that insurance policy might cover losses associated with the pandemic. Insurance policies these days often will exclude coverage for pandemics, but as usual, the best advice anybody can ever give you is read the contract, read the language. There could be limits on liability. In other words, even if there's a breach, it might be the case that the contract under certain circumstances will limit the breacher's liability for that breach. So in the event your client or maybe the other party is in the position where they might be held someday to have breached the contract, if there's a limitation on liability, you need to look at that provision to decide what is the settlement value of this case. If there's a limit on liability applicable, that's going to affect the settlement value. And then finally, in certain contracts, you might find a clause that refers to material adverse changes in the circumstances. So what is this talking about? This is a clause frequently found in contracts involving one party buying or acquiring the business of another party. And usually in a transaction like that, what happens is the purchasing party, the buyer, goes in, examines the books, looks at the business history of the company to be acquired, decides then to acquire the company for a certain price, but may insist on a provision in the contract that says, look, if there's some material adverse change in the business being acquired between now and when this deal is going to close, then here's the effect of that. Maybe the parties are each excused from performing, maybe there's a change in the price, etc. So again, look for any provisions in the contract that might be applicable, even if there's no force majeure clause. Okay, so Bob, maybe you can take me to my next slide. So even after you reviewed the express terms of a written contract, and you've looked for all the sorts of provisions I've just described. The language is going to have to be interpreted, and maybe the express terms of that written contract can even be added to for various reasons. So one doctrine you might recall from law school is the parole evidence rule. It's, as you also probably recall, many of my former students are still in psychotherapy as a consequence of that part of the course. It's a very complicated area of law. It addresses this question, are promises, agreements that the parties made prior to or at the same time they made their written contract, are those promises terms that can be considered additional terms, actually part of the agreement, even though they were not explicitly stated in the written contract. Complicated area of law, but watch for that sort of issue, particularly with respect to a contract, a written contract that was negotiated and created after COVID-19 became an issue in the news. Well, this only happened a few months ago, but once that became an issue in the news, there's a fair chance, at least, that the parties talked about, well, what happens if this virus gets out of control? How's that going to affect our contract? If that happened, then maybe there's a parole evidence issue. Parole evidence can also be admitted to interpret the terms of the written contract. So again, you want to talk to your client about what did you and the other side talk about, what did you agree, what did you say in connection with the creation of this written contract? Did you exchange any letters, any emails, correspondence that might have a bearing on what the terms are or how we should interpret them? And parole evidence, by the way, is evidence that often is described in a more general way under the heading of extrinsic evidence. Extrinsic is a fancy word meaning outside. Outside of what? Outside of the written contract. So there are other types of extrinsic evidence that could be admitted to help interpret a contract. You may recall from law school days, there are things like course of performance, course of dealing, trade usage. In the event there's some evidence, for example, that the parties started performing this contract and changed what they did once the virus became apparent, well, maybe that's relevant now, an indication of how we should interpret this contract going forward. And then the final point to make about the terms of the contract and what in other words, the contract says we should do because of the virus. Courts have the power to engage in what's called gap filling. In other words, here's what that means. The court looks at the contract and says, you know what? The contract just doesn't address what should happen in the event that only 30 people can show up at the reception hall. It doesn't talk about that. Or it doesn't talk about what should happen to Samsung's deposit in the event that we need to cancel, but we can apply that deposit to next year's trade show. So in the event the court decides, look, there's something missing in this contract, courts have the power, very broad discretion, to read into the contract something that the courts deem to be reasonable. That's a pretty broad power. Usually when a court engages in gap filling, the most convincing evidence has to do with what are the commercial circumstances, the typical way that parties in this sort of transaction would deal with the problem. That's usually what courts look to in deciding what's reasonable. But in the age of COVID-19, I think a court is also going to be influenced by all the legislation and all the public policy issues, all the public health related issues that are pertinent in this age. And I think it's very doubtful that a court is going to enforce, rather fill a gap with something that is inconsistent with what is in the interest of these public policy concerns. Okay, so Bob, final slide. So if you listened to our three presentations, you kind of get the idea that there are some. We're dealing with some contract law doctrines, the application of which in this COVID-19 context is not always going to be very clear. So there are some practical considerations to keep in mind if a client comes to you with a contract problem connected to the pandemic. So remember, the first party who engages in a material breach of a contract that's the party that usually is going to end up losing if you go to negotiations or rather go to litigation, or if a material breach has already occurred, that's the party that already may have squandered some of its leverage in negotiations. So, and also remember this next point, which I mentioned a couple of minutes ago. If you unequivocally repudiate your duties, your promises under a contract, and it turns out you're wrong, that you didn't have the right to do that, that's going to be considered a material breach. So you need to be careful about what you say, particularly in writing, about the position you're taking. The other side to that coin, of course, is if you don't assert a position, you may be deemed to have waived it. So you have to do the usual lawyer magic of using careful language to avoid making an unequivocal repudiation, but at the same time asserting that this is how you're reading the contract and this is what your client wants. As soon as you figure out what your client wants, it's going to be important to give notice to the other side of the problem. Do that as soon as possible. Lay out some options, if possible. If in the unfortunate event the case gets to court, if the written record shows that you were trying to work it out, you weren't asserting an unyielding position, you may be fortunate enough to have induced the other side to be the first to have engaged in a repudiation. And of course, throughout your dealing with the other side, you always have to keep in mind who's got the leverage here. It may be in our Samsung example, for example, that Samsung's a big company. The amount that they put down as a deposit may not be of consequence to them. It may be, though, that maintaining Samsung as an ongoing participant in this annual trade show is important to the party that puts on that show. So that may be a relationship that should have a future. That may indicate that Samsung's got a little more leverage in the deal. On the other hand, the poor father who may have given a large deposit to the owner of the reception hall, because dad has already given a lot of money, that owner of the reception hall now has got some leverage. Dad may be in a position now where he's got to strike some sort of a deal, the terms of which might not be optimal. And of course, the other thing you have to worry about always in dealing with the other side, particularly at a time like this, is questions of insolvency. It will do you little good to insist on a position that may put your opponent into bankruptcy, in which case your lawsuit may have little, if any, value. And certainly, from your client's standpoint, you can't take a position, you have to be careful about taking a position that will perhaps drive your client into bankruptcy when your client does not want to pursue that alternative. So those are just a few of the practical considerations. We're already 15 minutes over time, but we've received a number of questions in the chat. So let me first of all say a lot of you have asked for the slides, so we'll endeavor to get the slides to you. But let me run through the, and also as you may have noticed in the chat, we've indicated that this program is being recorded, so if you want to listen to it again, that's available. Here's a question that's come in the chat, and it's very similar to one of our hypotheticals. This is from Annette. She writes, I have a question. I have a client who's a wedding planner who was in a contract with a client for an October 2020 wedding date. Her client wants to reschedule the October wedding date, and the contract did not address the issue of rescheduling. The planner says she'd be willing to move the date in exchange for a fee. Her client did not agree to it, and now is asserting he has the right to rescind the agreement due to mistake. His argument is that had he known that there would be conditions on rescheduling, he never would have entered into the contract, and therefore he wants a full refund. What are your thoughts? I don't know, Brian, Bob, you want to comment on that one?
When was the contract entered into?
Doesn't indicate.
Because if the contract was entered into since the fit hit the shan, if you will, then one would say that maybe risks are being taken about whether or not this event could go forward on the date that had initially been indicated. And so one might say then that the wedding planner is not obligated to change if the deal was entered into during that time. If the agreement was entered into before, I wouldn't necessarily say it's a mistake. Mistake tends to focus on events existing at the time of contracting, not future events. Impracticability or frustration might be the more applicable doctrines, in my opinion, from the perspective of the father. It was a father, right? From the perspective of the father, I mean, that's like our hypothetical, it seems to me, that we posted. And you get into the question of whether or not this deal is substantially frustrated as a result of the COVID-19 circumstance. And, you know, again, I don't know how many people they were supposed to have at this wedding. You know, it's not just my thinking about this. I've read others comment on this, other attorneys, that the wedding can go forward. It's just that there aren't going to be as many people there. And it may be then that if the father wants to change the date, they can't necessarily hold the wedding planner to that. But the wedding planner also can't necessarily insist that the father pay. So again, as I say, I think it makes sense in these situations for people to try to work things out.
We've got another question having to do with the Samsung example. How can Samsung get its money back if it's paid the promoter in full, according to the terms of the contract, and it simply doesn't want the money applied to next year's show?
So,
Bryan? Yeah.
If you don't mind, since that was, I mean, I specifically addressed that, I think, and basically assuming that we say that the purpose of the contract is substantially frustrated, then we would say that when the event promoter proposes to extend the date a year, that's really a material change to the agreement. And assuming that we say that there is substantial frustration, I think that there's a good argument for that. We would say Samsung's entitled to rescind. They are entitled the law generally allows for restitution in these cases unless the contract says otherwise. So the parties could contract and say this is an absolutely non-refundable deposit. Or it could say that in the event that the show can't go forward, we will apply it to next year. It could say things like that. And Samsung, being a big player, is not going to be protected from itself probably in that situation. But if the contract's silent, I would say they don't have to go along with what's being proposed. As you said, Vic, probably they have the power here anyway. I'm guessing that any trade show that Samsung's involved in, they're probably going to want to have Samsung there. So my guess would be that the event organizer would be willing to make some kind of an arrangement with Samsung. But I think legally they would have a right to get their money back, and they wouldn't have to agree to go forward.
I think, you know, for all of this, the last place you want to be is litigation. So it's just the kind of who has the stronger legal position to start the negotiation. But this issue is going on right now with the Hollywood Bowl. The Hollywood Bowl has canceled the season. They fully anticipate, according to the email I got, that they may be permitted to have, you know, some people come. There'd be social distancing, but there may be acts could, you know, come and people could sit every other box or every other seat or something. And they have the issue about whether they're not they're obligated to refund the money or take it into next year, you know, or we'll apply it to next year's season and all that. Now, they're being pretty good about it and saying, you tell us what you want to do. But if they didn't, it's the same issue, and it's really just the beginning of a negotiation, I think.
We have another question, but this may have been covered. What if the wedding simply cannot go forward due to a government stay-at-home order that prohibits, big gatherings?
That one I think is relatively straightforward. I think if the guy, if performance is impossible because it's illegal, I can't imagine any court requiring the deposit not to be refunded.
So the father has got a frustration of purpose case, and the wedding planner, or rather the wedding planner or the hall can't be sued. They've got impracticability or impossibility as a defense. So, and there's another doctrine that we haven't mentioned here that might be applicable, which is if the father is given a big deposit and the hall does not want to give it back, that might present a claim of unjust enrichment also. That's something I like to talk about in my contracts class. If a contract is not enforceable, maybe there's an unjust enrichment claim.
Generally speaking, when there's excuse granted on the basis of impracticability or frustration, if either party has actually given money, say, to the other one, unless the contract says otherwise, they have an argument to get it back under the theory of unjust enrichment or restitution.
Right. Last question here. Is there any decided litigation on these issues concerning COVID? Anything come down?
I've looked and read others who have looked for about as of a week ago, and the answer was no. So
yeah, it's pretty early.
I think it's too early in the game. Yeah, I actually did see one case. I looked a couple days ago too. There was one case where they were actually trying to raise it as an impracticability type argument, but basically what the court said was too early to tell the extent to which the person who was trying to get out that their supply chain had actually been cut off. So it was premature.
Yeah. So it's early in the game, but I think it's fair to say there will be plenty of litigation that follows.